Hi, everybody. Here we go. We are now starting the third quarter of the Constitution course, and it's time to get your lawyer on. Okay. Now, there's a lot of material to cover this week, so I'm going to take it kind of slow because these are sort of, we're setting the table for all the Supreme Court cases we're going to look at and to understand the context of these cases, how they came to be, how they were ruled on, why they were important, why they continue to be important. There's a few legal terms that we have to get a working familiarity with. Now, I am not a lawyer. Don't pretend to be a lawyer. Didn't even stay in a Holiday Inn Express last night. Maybe your parents get that joke. Anyway, but I think there are some terms and some situations that we all have to understand in order to, again, proceed ahead. Okay, so let's look at the first one. The most important article in terms of the court is Article 3, Section 2, which establishes the jurisdiction or the legal ability to hear a case of the Supreme Court. And again, here the founders are pretty clear. They divide the responsibility, the roles and responsibility of the court into two cases, right? The court has original jurisdiction, meaning a case is tried directly before the Supreme Court over certain cases. And there's a little bit of a laundry list there, okay? I think the most important one for our situation in our day is the Supreme Court can have original jurisdiction over suits between two or more states. This is very important. And or cases involving ambassadors or other public ministers, okay? For the most part, the Supreme Court has and exercises appellate jurisdiction, which means they hear a case on appeal, right? When you read the newspaper, if they're reasonably honest, they will talk about a case that has basically wound its way through the federal district courts, maybe the federal circuit courts, and then it goes to the Supreme Court. If you look at a bunch of recent cases, what we'll typically see is when a case has an outcome that is ruled on in a particular circuit court, and a very similar case is ruled differently in a different federal circuit court, somebody will typically appeal to the Supreme Court to say, this circuit court says this circuit court says that. What say you, Supreme Court? Right? This is pretty much my interpretation, having followed a number of recent Supreme Court cases, of how this happens. Is circuit court decides this, other circuit court decides something totally different on the same set of facts or similar circumstances, and it ends up in the Supreme Court, okay? The other thing that of course the court has original jurisdiction on in cases in which the United States is a treaty, and interesting admiralty cases, which involves ships on the high seas and navigable waterways. We're going to see one of the first and defining cases of the Supreme Court involves navigation and commerce rights on waterways between two states. Okay. Couple of other very important terms is the power of judicial review. This is the best known power of the Supreme Court. It's just the ability of the court to declare a legislative or executive action in violation of the Constitution. This power is not found within the text of the Constitution itself. As we will see, some of the very early cases of the Supreme Court, you've probably heard of some of them. The court started to exercise its independence. It's from the legislative or the executive branch. And the way that they did this was they anointed themselves with the power of judicial review. The other thing that's very important in legal terms is precedence, right? This is the legal notion that a court decision is considered an authority for deciding subsequent cases involving identical or similar facts or similar legal issues, right? This is the whole basis of arguments before the Supreme Court in very controversial cases, particularly Roe versus Wade, that the precedent of Roe versus Wade trumps any attempt to change it, modify it, or reduce it, right? This is where that overly ridiculous phrase from a certain senator from the state of New York, I won't name his name, says that Roe versus Wade has super duper precedent, which is about the dumbest legal term I've ever heard, since we could say that, as we're going to find out later, Plessy versus Ferguson could have had super duper precedent, and in fact, it did not. So precedence is a very slippery slope, particularly for the Supreme Court. There's a large body of writing that says the Supreme Court is very reluctant to overturn an earlier Supreme Court case because it might make themselves look bad, unless the case is so egregiously bad, such as Plessy versus Ferguson, that they really have no choice but to do so. We're going to talk about this a lot in a number of cases. Now, the other thing that's very important to remember and keep in mind as we go through these cases is looking at the concept of an originalist versus a living constitution viewpoint. This is probably one of the most controversial aspects of looking at constitutional law today, as there is a large body of lawyers that say that we need to not be so hidebound to what's written in the Constitution. The Constitution is a living, evolving document. These are pretty much the textbook definitions here, right? Originalism is a concept that says that all statements in the Constitution must be interpreted based on the original understanding at the time it was adopted. This is why, as we noted in the last quarter, the Federalist Papers that I assign for you to read and understand are very important, because they do, for the most part, play a role in how the Constitution is interpreted today. This is where you will get the split between what might be termed the conservative and the liberal justices of the court, right? The liberal justices of the court are very much, from my observation, willing to interpret the Constitution more as a legal document. Basically, what they will say is the living constitutionalists will argue that we cannot apply an original understanding of the Constitution because the document is too old and too cryptic. It's not cryptic, it's very brief. And as we discussed in the first quarter, it was and part of the second quarter, it was very brief because the drafters, the original founders, knew exactly what they meant. They knew and understood each other. So they didn't have to put fine print because they all knew exactly what the intent, the intent of the Constitution was supposed to be. So as we go through these cases, keep in mind these terms. Now, these are in your syllabus, and of course, you'll be receiving these slides. I'm going to flip back here for a second. Look at original versus appellate jurisdiction, okay? Keep that in mind. Judicial review. Most of the cases that we're going to look at come up to the Supreme Court because of judicial review. There are a couple where the court exercised its original jurisdiction, but for the most part, all of the cases that we're going to look at in the following weeks come from judicial review. Precedence is also very important. We're going to see that over the course of history, precedence remains and is still used today. You will still see current Supreme Court cases that will cite Marbury versus Madison, may cite Brown versus Board of Education, McCulloch versus Maryland. But so precedence is really important. The other thing that's important to look at is the originalist versus the living Constitution. I would say that for the most part, I think that this is applied in Second Amendment cases when people are arguing over what is exactly the right of the citizen to keep and bear arms in terms of a militia, right? A militia, of course, was very much a part of the colonial experience of the founders. Like everyone was in the militia in a town. Every male over the age of 16, 17, 18, whatever that particular town has, was expected to have a musket and to know how to use it and to be part of the militia that was subject to being called up to help defend the town, okay? Nowadays, they tend to interpret, living constitutionalists tend to interpret that very differently. So these are real issues that we have to keep in mind as we start getting into these Supreme Court cases, okay? So take some time this week, read over what's in here, okay? There's not a lot of outside readings. However, I did put in your syllabus some links that you might find useful as we go through and start looking at these cases, or for some additional background. So if you take some time to click through some of those links, I think that will also be very important as we start going through to start building sort of your own database of how you're going to step through each of the courts, okay? All right, next week we start